So what they've actually got? This is well before the Act. I think the thing is there are offences which are connected with with an election which aren't done by existing members or candidates. It actually is to do with parliamentary privilege because Parliament can only debate its own affairs and business, right, of its own members. But members of the public can commit election offences and they can be prosecuted. It seems like because there's a lot of offences under the Representation of the People Act and Corrupt and Illegal Practices Act that can be prosecuted through the courts, right? But the thing is that MPs have got parliamentary privilege, right? And I don't think that they could be tried in the court or even be debated or argued in the court. So that the MP themselves was treated separately, and that's why they debated the seats of the members in Parliament, right? Because the courts couldn't debate it when it was the candidate. I think maybe the candidate or whether they were already an existing member previously, right? And that's the part that they debated in Parliament prior to that, because it was, after you've been elected, if there was a contest. You see, once you've been elected, right, and you become a member, then you've got privilege, right? So then it has to, but because of the corruption of the members debating their own privileges, that's why it was extended to the courts, so MPs could stand as well. But if you read the Election Petition Rules 1960 and the Corrupt and Legal Practices, people who are privileged have got to turn up in court and answer questions, right? But they still might be subject to their privilege. Now, there are particular sentences and punishments like imprisonment and so forth, but I think that's why they send it to the Speaker of Parliament, right? Because, you see, because of privilege, because of the election is matters to do with Parliament, right? This is why they have to give it to the Speaker, and then they have to have an election. They get a recall of MPs petition and so forth. It's to do with literally, it's a bit like Lord Hanningfield basically when he was in Southwark Crown Court, kind of sort of like that kind of situation. Because the court wouldn't have been able to determine if the MP had been criminal or not, because they're not allowed to debate matters of privilege. But it's strange that the whole election's to do with Parliament, and other people could have been prosecuted. But this is why they prove this agency. Agency itself means that you're engaged in the workings and runnings of the election, the processes and procedures, right? That really should give you privilege. But when they opened it up to the courts officially in 1868 afterwards, but this is the thing with the right to petition and the subjects when we're petitioning Parliament, when we are bringing a petition to the House of Commons Petitions Committee, and when you're collecting your signatures and going about doing it, you've got agency. Now, this is the thing in the protests. What they're doing with this Public Order Act and most of these protesting and demonstration offences, right, is they're saying there's no agency, right? That it doesn't exist, as if it's just some kind of football match protest or music event protest, right? Because it's not anything to do with a Parliament casework, right? But when you're petitioning the government and going around collecting signatures or canvassing or advertising it, you have got agency. But this is the thing, you see, the petition itself is your document, it's your evidence. And through the 1640s, up till 1661, you used to get these writs of privilege, and then onwards up to 1688, because it was only really your agency was acknowledged by the courts or Parliament. If it got challenged, you got your certificate, your privilege certificate, which they have these in election petitions as well, when there's certain agency involved, and actually for witnesses as well. But in 1688, in the new constitution, in the Bill of Rights, what they're actually doing is creating our own law in the constitution. So if all people who are petitioning cannot be prosecuted or imprisoned, okay? It's not such a big deal when they got rid of all imprisonments for tort cases, for civil cases. People were getting put in prison and arrested and all kinds of things for civil cases, right? So if you think about that, it's a real privilege now to not have to be arrested or go to prison for owing people money, right? In a civil court. So it's actually, if you think about it, for the right to petition and serious matters and cases to Parliament, it's not that, it wasn't, it was a big deal, but they already had it before then. But you'd got to get, all your paperwork and documents in order. And they might not have upheld it. The sheriffs weren't upholding a lot of these writs of privilege. Now, when they made it into the Constitution, it's actually law, right? It's explicitly law that if someone is petitioning, they can't be arrested or prosecuted. Now, how would you prove that you were doing it? Well, because if you've got a petition or not, right? If you've actually got the petition, then there's no doubt that the law supports you. There's no question. You don't have to, get Parliament to back you up with these writs, okay? That's what it is. Now, Parliament itself, if you are engaged in Parliament, then there's parliamentary privilege, okay? But there might not have always been a Parliament, because Parliaments can get prorogued or dissolved, right? And you have to petition the King directly, or the King and Council, in between Parliaments, right? So you can't get rid of privilege from Parliament if they don't have one, okay? And that's why the Constitution protects you, with or without Parliament, if you're petitioning, the King, right? Now, the thing is that Thomas Erskine May says that if you do any fraud or forgery on a petition, right, the petitioner can't, it's forfeiting privileges, okay? But, ironically, that means that if MPs, right, do fraud or forgery, they forfeit their privileges, which means that they can be impeached, right, by other members of Parliament, right? But the petitioner, the public, has got his very own law for us, which is not reliant on parliamentary privilege. Because if we're petitioning the King's writ, right, which is either Hours of Parliament or the King, you can't be prosecuted. You cannot be prosecuted. You don't need Parliament to back you up, because the law, the Constitution, backs you up, right? But when you are petitioning the House of Commons, you've got agency with it. And that's what the currently Speaker doesn't want to acknowledge, that members of the public can have agency, which is what, when a printer prints something from Parliament, that falls under processes of Parliament, so that's agency, right? So you've got Parliament. What Erskine May is saying is that petitions to the House of Commons is covered with agency, so it's covered with parliamentary privileges. So you're entitled to a certificate from the Speaker of Parliament, right? But you don't need one if they recognise and acknowledge the law, which is the 1688 Bill of Rights, because the law protects the petitioner regardless of whether or not Parliament back you up or not, as long as there's a petition. But it doesn't have to be a petition to the House of Commons. It can be a petition to the House of Lords or to the Privy Council and King, right? Possibly even to the local council, because they've got like the King's Mace in the chamber, right? Could be a petition to the local council. So you actually, when you're petitioning the House of Commons, it's almost like these hybrid cars that have got petrol and electricity, right? They can run on electric power or petrol, right? And that's what happens when you're petitioning the House of Commons. Now, you've got the 1688 Bill of Rights, which protects you in constitutional law, right? Which the courts are meant to acknowledge, but they're not doing. What proves that you're doing it is if you've actually got a petition or not, right? Because you don't need a writ of privilege, because it's like the 1688 Bill of Rights is the law. All you have to, if you've got a petition, then you're covered with that constitutional law. If you produce it, your actual petition is your proof. But then, if it's to the House of Commons, you have actually also got parliamentary privilege as well on top of that, and you are entitled to, ask for Parliament to prove that, which is why you get those writs of privilege which are prescribed in the Parliamentary Papers Act, and it does, 1840, and it does extend to evidence before a committee. It does extend to evidence before a committee. But in Hansard, they're saying, in this Lord Denman, when they make that act in 1837 to 1840, with Baron Denman, they're saying that, the petitioner cannot be punished even if he has fraud or forgery, because of the right to petition. but it does forfeit parliamentary privilege. But but you've still got that other act backing you up because it's an explicit act, which basically means that but the thing is, the basis of a petition is that you're trying evidence. You know, it might not necessarily be true, but you're trying to prove that it's true. Okay, you know, there are millions of cases that go through courts where someone might have lied in the court, even a witness. We don't know for the fact, but they were on oath, and people might be in prison because of false information, but it might have been believed in the court. I think that's meant to be the initiative behind that 1688 Bill of Rights. You know, you're trying information, you're trying to prove it. I'm not saying that you should lie, but you're attempting to prove it. You're trying a case. And in normal criminal legal proceedings, you know, you've got offences like giving a false statement and so forth, but that does not supposedly apply to the 1688 Bill of Rights. But anyway, this is all about elections anyway. This is to do with specifically elections. And with an election, it's different to a petition because it's government facilitated, whereas the petition, you've got to kind of do it all. It's all your own efforts. These elections are all government facilitated and run with polling stations and staff and things like that. And that's why they're more regulated and there's more rules for MPs. So, you know, I don't know how the Electoral Commission can ignore this legislation. And the Electoral Commission should do something about Michael Westwood's petition to Parliament call a general election as well.